Common mistakes that disability carriers or plans make in their denial or termination letter that violate ERISA regulations. Hey, I'm nationwide disability attorney Nancy Cavey, and I am often called by a prospective client about a denial or termination letter that they've gotten. And I will tell you, these denial or termination letters are confusing, they're inaccurate, they're misleading, and of course they're aggravating. You read the letter and you wonder, what on earth don't they understand? What on earth do I have to submit to win my claim, and when do I have to do it? Now, I will tell you, one of the most common mistakes that disability carriers make is failing to accurately summarize the medical records that were the basis of the denial or the termination, or any scientific or medical literature that they may be relying on in contesting your claim. In fact, if they cite it, they certainly don't supply it. Now, I will tell you that there are many mistakes that violate the ERISA rules and regulations, and I think that these are the starting point for filing a winning an appeal letter and getting your benefits. Let's first talk about this ERISA statute. You have 180 days in which to file an appeal of a denied or terminated benefits, and that appeal is the trial of your case. You have to exhaust your administrative remedies before you can file a lawsuit. And that's why it's so important that you understand the basis of the denial or termination. Under the ERISA regulations, the disability carrier has an obligation to allow you to have or an opportunity to have a full and fair review of your denied or terminated benefits. Otherwise, the carrier can hide and move the goalposts, which they do all the time. So in this denial or termination letter, you will often see a sort of a summary recitation of the reasons for the basis of the denial of termination, talking about the applicable policy language. But I'll also see this inaccurate, cherry-picked summary of the medical records. They misquote things, they highlight things that aren't important, they ignore things that are important. And obviously you want to understand what records they had, how they were cherry-picked, who cherry-picked them, because they're going to use liar-for-hire peer-review doctors. And you need to understand ultimately what it is they want to re-review your file. So it's really crucial that if you get a denial or termination and you think that the summary of the medical records are inaccurate or incomplete, or they're relying on bogus medical literature, it's time for you to contact nationwide ERISA disability attorney Nancy Cavey. I can help you get the disability benefits you deserve regardless of where you live in the United States. Let's take on that wrongful denial or termination. 727-894-3188.